indeed before CAS or ICAS. As for the challenge on the basis that the award was contrary to Swiss public policy, the court observed that there was in fact no significant public policy issue raised, and that Pechstein was merely seeking to re-litigate the merits of the decision reached by CAS. In March 2010, so very shortly after the decision came down, Pechstein filed a further application to the Swiss court seeking revision of the award on the basis of new scientific evidence. The Swiss courts also rejected that application on the basis that the threshold for the admission of new evidence were not met in that case. Pechstein returned to international competition when her ban ended in 2011, and indeed she competed in the 2014 Winter Olympic Games, coming fourth and fifth in different events. She's also subsequently won further medals at World Championships. Notwithstanding that, in 2013, I believe, she commenced litigation in the German civil courts, seeking damages for alleged losses of several million euros suffered as a result of the allegedly wrongful actions taken by the ISU in banning her from speed skating. In response, the ISU sought to rely first on the CAS award, but secondly also on the decisions of the Swiss courts as precluding the claim made against them in Germany. A first instance court in Munich held that the arbitration clause in the ISU participation agreement was invalid, but they held that Pechstein was precluded from pursuing her claim for damages because the issues that she wished to raise, the issues she wished to raise had already been decided against her, and those decisions had to be given effect to in Germany. Pechstein appealed that judgment to the Munich Court of Appeal, and on the 15th of January of this year, the Court of Appeal delivered its judgment. And it's this judgment which has been described as earth-shaking, revolutionary, and to have put the future of CAS in the balance. The Court of Appeal allowed Pechstein's appeal, and it held that the CAS award was not recognisable and enforceable in Germany on public policy grounds pursuant to Article 5, Paragraph 2b of the New York Convention, which again is on the screen now. It therefore said that Pechstein's civil damages claim against the ISU would continue. In outline, the Court of Appeal's reasoning was as follows, and it is important, I'm afraid, to take this in just a little bit of detail. The Court of Appeal said this. It said that ISU is in a monopolist and dominant position in the market for organising speed skating competitions. Therefore, as a matter of German and European competition law, ISU was obliged not to abuse its dominant position when offering services, including the right to participate in international competitions, by forcing consumers to accept terms which differ from those which they very likely would have agreed to if true and effective competition had existed. The court then continued. ISU's imposition of CAS arbitration was not itself an abuse of ISU's dominant position, but it was an abuse in this case because the form of arbitration that it enforced on athletes was, in the view of the German the Munich Court of Appeal, not a neutral form of arbitration. It was not neutral, said the court, but rather was institutionally weighted in favour of sporting associations and against athletes. It said there was a one-sided designation of potential arbitrators favouring the sporting associations. It then said this embedded structural imbalance threatened CAS's neutrality. And it created the risk that persons included on CAS's arbitration list would predominantly or even entirely favour the side of sporting associations over athletes. It said this was true even of the arbitrators selected to represent athletes, since they were designated by ICAS, and the ICAS members were predominantly chosen by national sporting associations, international sporting associations. The court then said there was no objective or rational justification for this imbalance. And therefore, and this is the court's conclusion, the imposition of the CAS arbitration clause in those circumstances was an abuse of ISU's dominant position in the market. That was a violation of competition law, and therefore the CAS award based on it could not be recognised or enforced in Germany as being contrary to German public policy. Therefore, the Court of Appeal said Pechstein was free to pursue her claim for civil damages in the German courts. An appeal from the decision of the Munich Court of Appeal is currently pending to the German Supreme Court. The decision is expected sometime in the first half of 2016. For the sake of completeness, very briefly, Pechstein has also brought a petition before the European Court of Human Rights against Switzerland, claiming that the processes available to her for review of the CAS award in Switzerland did not protect her rights to a fair trial and her right to a fair hearing. That decision of the European Court of Human Rights is also pending and is expected in early 2016. I'll now move briefly on to the issues that arise out of the Pechstein judgment as I see them. The first is specifically an international arbitration issue, and that is one of cost and finality. The Pechstein saga so far has dragged on for already 7 years, and indeed is far from finished, as there are a number of pending judgments still to be determined. This is plainly not a compelling endorsement for the merits of arbitration as a means of dispute resolution in the field of sports. Arbitration, as we all know, is often lauded for its speed and finality, but those features are plainly not in evidence here. As to my view, although this is arguably an extreme case, it is not wholly exceptional. It indeed is reminiscent of battles in hard-fought commercial litigation and arbitration, where a losing party will deploy all means available to it, both before and after judgment is given. And indeed, the international arbitration system permits objections to be raised both at the seat and whenever and wherever recognition and enforcement is sought. So I don't believe that the threat to the cost and finality, or the threat posed by the cost and finality of this saga is truly a threat to international arbitration or the CAS scheme. The second issue is also an international arbitration issue, and it concerns the independence and impartiality of CAS tribunals. This really, in my view, is at the heart of Pechstein's case before the German courts, even if, rather cleverly, it was presented as a public policy and competition law argument. The concern is that CAS is institutionally weighted, or that ICAS in the first instance and CAS in the second instance is institutionally weighted in favour of sporting associations, since they appoint 3/5 of the members and those members appoint the balance. That's of the body of ICAS. And also, in the view of the court, one of the concerns was that many of the appointees to ICAS, even after they are appointed, maintain their allegiances and their affiliations with national and international sporting institutions. In my view, this ought to be a fairly simple matter to resolve. There is likely to be some stakeholder resistance, but since, as I assume, the common intention of all is for there to be a fair, reliable system of decision-making, resulting in binding, final and enforceable decisions, it should not be impossible, nor even all that difficult, to revise the ICAS and CAS institutions so as to ensure that they meet modern standards of independence and impartiality. A third international arbitration issue is the timing of challenges. This is a topical issue in international arbitration more generally, and indeed there are a number of cases with some inconsistent results in different jurisdictions as to the ability to raise challenges in later proceedings when they could have been made at an earlier stage. It is clear that challenges to jurisdiction can be brought at any stage in the process, and challenges based on the public policy of the place of the court that's considering the matter can, of course, only be brought before that court. However, other complaints, including complaints as the independence and impartiality of a tribunal, can and should, in my view, be brought first before the first tribunal that considers the matter. No doubt the force of that is why in the German courts, Pechstein characterised her complaint as one of public policy and competition law, even though it was in truth a complaint about the independence and impartiality of the tribunal. A fourth set of issues concerns sports law and governance and control. Conscious that I'm well over my time, I won't refer to many of those. The final set of issues arise out of the competition law public policy approach of the German courts. And to the extent that Pechstein actually raises issues of competition law rather than just independence and impartiality, they may be somewhat more difficult to resolve both conceptually and in practice. Competition law differs in different jurisdictions, of course, and it's a particularly difficult body for non-specialists of that form of law. And indeed, it's still a developing body of law. But I would say this from the perspective of international arbitration. In the face of the challenge posed by Pechstein and other cases, if they do truly raise competition law issues, national courts and administrators and sporting bodies and other users of the system, including individual athletes, need to be conscious not to ignore the benefits of international arbitration. They include access to swift and often cheaper justice, confidentiality, accountability of state bodies that may not be possible to achieve in domestic courts, and also independent